Welcome to this week's Ask an Atheist. My name is Rebecca Markert, and I'm the legal director at the Freedom from Religion Foundation.
I am Andrew Seidel. I am the Director of Strategic Response here at FFRF.
And I'm Patrick Elliott. I'm Senior Counsel.
So last week, the U.S. Supreme Court wrapped up its 2019 October term, and today we are going to discuss the major cases that impacted religious liberty and what that means for the future of state-church separation. As always, if you've got questions or comments about today's show, you can leave them right here in the comments on Facebook, here, there, wherever it is, or send an email to askanatheist@ffrf.org. That's askanatheist@ffrf.org, and we will get to those questions later in the show.
So FFRF was following 4 cases from this last term that affected our work. 2 of those cases we previously discussed on the show. At the beginning of this month, Brendan Johnson and I discussed the Espinoza versus Montana Department of Revenue case, which allowed government funding for religious schools. And just last week, FFR co-president Annie Laurie Gaylor and reproductive rights intern Barbara Alvarez discussed June Medical Services versus Rousseau, a case involving admitting privileges for doctors performing abortions in Louisiana. But last week, the court handed down 2 more decisions affecting our work, and it didn't end on a good note for us.
No, it really didn't. The court ruled 7-2 in favor of expanding the ministerial exception. We'll talk about that in a little bit. To teachers at Catholic schools in a case called Our Lady of Guadalupe v. Morrissey Baru, and that was actually 2 cases rolled into one. That same day, the court ruled 7-2. It was really a 5-2-2 split, which we may talk about later, but 7-2 basically allowing an exception to the ACA's contraceptive coverage provision on religious and moral grounds in the case called Trump v. Pennsylvania, or as many have been referring to it, particularly in our office, the Little Sisters of the Poor case.
So let's discuss the Little Sisters case first. This was a case that was argued in May. It was supposed to be discussed earlier this spring in March or April, but was postponed because of the pandemic. The arguments were actually held via telephone, and live arguments were assessed to the public for the first time ever. That factoid aside, Patrick, why don't you explain what the case was about?
Sure. So this was a challenge by the states of Pennsylvania and New Jersey against a new rule that the Trump administration created, which expanded exceptions to contraceptive coverage by employers. And that would include both religious or moral reasons. And so litigation over these types of provisions have been going on for many years, I'm sure as many people know. But this is the latest iteration of that. And so the Supreme Court decided in this case that the Trump administration had authority to massively enlarge the contraceptive mandate care exceptions, and also that its process for doing so wasn't procedurally improper. So that doesn't end the entire litigation. While the court ruled that this was procedurally proper, it's not a definitive answer from the courts in terms of the contraceptive care exceptions for these moral or religious reasons. And so the challenge remains live, and Justice Kagan, in a concurrence, wrote about some aspects that are probably going to become relevant as this case continues. And she wrote, other aspects of the department's handiwork may also prove arbitrary and capricious. For example, the departments allow even publicly traded corporations to claim a religious exemption. That option is unusual enough to raise a serious question about whether the department adequately supported their choice. And so the lower court's now going to have to answer this question of whether it was a reasonable or whether it was an arbitrary decision in including things like publicly traded corporations, including the moral exception besides just the religious exception. And so we may not have an end to this litigation for quite some time.
Yeah, and Pat, as you mentioned, I mean, this is already a very convoluted case. It's been going on for 5 years, and it all comes down to the contraceptive mandate. That's what we're really talking about. And one thing that has been lost in the coverage of this case and all the Little Sisters cases is the burden, right? So the nuns, the Little Sisters of the Poor, the nuns, their whole argument is premised on the fact that their religion is burdened by having to provide contraception to employees, which is kind of hilarious if you think about it. But keep in mind that they're already exempt from the contraceptive mandate. So how can their religion be burdened? This is getting lost in this discussion. Well, to get that exemption, you have to fill out a form to let the government know you're exempt. So, Bruce, can we throw that form up? There it is. And that is what the nuns are claiming is the burden, a form. This is the form that supposedly burdens the free exercise of religious schools and nuns and nonprofits. It's 2 pages long, and there are only 5 blanks. 5 blanks. You probably can't read them all. You have to fill out your entity name, the name of the individual filling out the form, the mailing address, sign it, and date it. That is it. This is the challenge that's at the bottom of multiple Supreme Court cases. Honestly, it's just ludicrous.
And they also don't have to provide notice to their employees that they're opting out, which I also just find ironic because they have not been quiet at all about their refusal to provide this coverage.
Yeah.
Now, Ruth Bader Ginsburg wrote the dissent in this opinion, which Justice Sotomayor joined. And she argued that Congress intended to give women access to services like birth control, and this ruling would have between 70 to 125,000 women lose access to birth control. She pointed out that the privilege was given to religion here. She wrote, "Today, for the first time, the court casts totally aside countervailing rights and interests in its zeal to secure right the nth degree."
That was the wrong image up there.
A quote from Justice Sotomayor, but I was reading from Justice Ginsburg.
It's all the fun. This is the fun of all the virtual commuting.
But the Ginsburg dissent is great in terms of highlighting the impact on people, and we had signed on to a friend of the court brief, basically reiterating some of those same concerns. So it was obviously a troubling decision overall, but that there are justices on the court who are recognizing the major impact in these cases and their impact on real people and real women that are facing the consequences of these decisions.
And as we pointed out, this is not the end of litigation when it comes to this contraceptive coverage mandate and the ACA. We're going to likely see more of that in the future. Right now, I want to turn to another significant case that came down last week, Our Lady of Guadalupe. After the Bostock decision came down a few weeks ago, which is the one that prohibited discrimination against our LGBTQ friends in employment, we were all waiting for this case because we anticipated it to be the but. It's the you can't discriminate except if you're a religious organization ruling that we were all expecting. Patrick, can you enlighten us about the facts of this case?
Yeah, and as Andrew noted earlier, it's really 2 consolidated cases, and both deal with what the courts are calling the ministerial exception to what's really an exception to following civil rights laws. And so those would allow religious organizations, typically churches, to make employment decisions or to fire their ministerial employees for any reason. And that could include things because of race, sex, or other protected status. So here, the plaintiffs were 2 teachers in Catholic schools in California who claimed that they were discriminated against in employment. Agnes Morrissey Biru sued for age discrimination after her contract was not renewed after 16 years as a teacher. And Kristen Beal was being treated for breast cancer and also lost her job. Tragically, she died as litigation continued. Her husband continued on the case. Both of these teachers had won in the Court of Appeals before the Ninth Circuit. And the schools then appealed that determination to the U.S. Supreme Court.
So the question before the court was whether this ministerial exception applies to those teachers. Now, generally speaking, one would think that a ministerial exception applies to ministers, pastors, priests, other clergy who are in the leadership of their church or house of worship. Andrew, is that what it is? Or can you tell us more about this exception?
Yeah, I mean, that's what it should be, and that's what it's supposed to be. So the ministerial exception, everybody needs to understand it's not a law, it's not a statute. This is a judicial construct. It was invented by the judges. And basically, what it says is that our government is not going to get involved in internal church matters. Churches have a certain level of autonomy, and they're not going to be able to turn to the government to resolve their disputes. Now, that's not a principle that you can read in the text of the First Amendment. That principle only exists as an offshoot of the larger, more universal principle that FFRF exists to protect, right? That quintessential American ideal that there's a separation between state and church. So that is the only reason, state church separation, that courts have created this ministerial exception. Okay, so state church separation is essentially, it's a prerequisite for the ministerial exception and the church autonomy that is embodied in this. And it goes back even farther. You know, we've had earlier cases where you have churches splintering off from each other and claiming that property is theirs as a matter of doctrine, and the courts have just said, look, we're not gonna get involved and decide what the doctrine of your church is. That is not for us. And it is, that is probably a correct reading of separation of state and church. But the problem here is that it's gone much, much too broad. So you have these two women who are teachers at a Catholic school who they cannot be ordained by the Catholic Church. And then the Catholic Church is claiming that they are ministers and they can therefore fire them for whatever reason they want because it's an internal church matter involving faith and doctrine and stuff like that. It is, so this is, while the ministerial exception is probably correct as a matter of law, this is an absolutely just blatant expansion that clearly favors religion unconstitutionally.
Yeah, and the court in favor of the Catholic schools, 7-2. They are allowed to discriminate against these teachers for any reason. And just Alito wrote the court. Excuse me. Patrick, can you explain why this won? What was the reasoning?
Yeah, I mean, it's reiterating, to be fair to what they're saying, which I disagree with, is reiterating the points that Andrew's talking about of not getting involved really in church affairs. It's just a matter of degree here that we think that this is an extreme exception, that it shouldn't go this far. But Justice Alito, I can explain some of his reasoning. We have a quote from him where he says, "The religious education and formation of the students is the very reason for the existence of most private schools, and therefore the selection and supervision of the teachers upon whom the schools rely to do this work lie at the core of their mission. Judicial review of the way in which religious schools discharge those responsibilities would undermine the independence of religious institutions in a way that the First Amendment does not tolerate." What's a bit ironic about this quote is the decision by the Supreme Court just a few weeks earlier where they ruled that the state of Montana had to fund religious schools and couldn't just prohibit the funding just based on their religious status. So in contrast to this quote seems to be saying how embedded religion is within religious schools such that we couldn't be involved in any employment type decisions on teachers, even though they're not teachers that we normally would associate as being ministers. As a former Catholic myself, I never thought that the teachers at the schools were equivalent to people within the religion like nuns or priests, certainly. So I think this is a pretty extreme decision from the court, but they're using kind of state church separation against us and saying, hey, we don't think the courts can get involved in who can be teachers at these religious schools under the facts of these cases. So there may be some teachers, certainly at the high school level, that teach just sciences or certain subjects. Maybe they would be covered, but it's pretty disturbing that that Alito and the court has kind of gone along with this idea that teachers in these schools must be considered ministerial.
And you brought up an interesting point. I am also an alum of a Catholic school, and I know for certain that there were teachers, especially in my high school, who were not practicing Catholics. Even they would tell us that they're not Catholic. And one of the plaintiffs in this case was also not a practicing Catholic. She filed an affidavit saying that she was not. But for all intents and purposes, the schools were saying, yes, she is. Do you want to talk about that a little bit?
I mean, it's certainly, it's humorous in some sense where the person themselves is disclaiming that they're a part of the religion. And really, it's a factual issue. I mean, this is something that should go to a court or a jury to decide rather than have the Supreme Court just determine it as a matter of law, that of course they're covered by the exception. When the employees themselves identified with a different religion, it's kind of hard to call them a member of the Catholic religion. We did have obviously some dissenting justices, talk about some of these issues. Justice Sotomayor, in his dissent, says, overall that the exception, it gives an employer free rein to discriminate because of race, sex, pregnancy, age, disability, or other traits protected by law when selecting or firing their ministers, even when the discrimination is wholly unrelated to the employer's religious beliefs or practices. And she notes how it's ripe for abuse, and she points out, over 100,000 secular teachers whose rights are at risk, and that says nothing of the rights of countless coaches, camp counselors, nurses, social service workers, in-house lawyers, media relation personnel, and many others who work in religious institutions. So this is a major concern for how this is going to be applied. In other contexts, and other employees now are at the whim of their religious employer, and they may not even consider themselves religious employees or tied to the employer's religion.
Yeah, I mean, this is a huge expansion, Patrick, and this is what FFRF tried to argue in our brief to the Supreme Court. We pointed out that, I mean, there's 1 in 6 hospital beds in the country right now are controlled by Catholic hospitals. And they are going to use this, right? They're already governed by the UCC SB guidelines, these bishops' guidelines, which put religion over patient welfare. Everyone employed by a Catholic hospital is a minister in that sense. If the UCCSB or the hospital argues that, for instance, spiritual health is critical to physical health, which it will, and that would give them the ability to fire any of these employees without regard for their rights, to just violate wantonly civil rights law. And everybody needs to remember too that this isn't just talking about disability, which was the case here, or age, which was the case. I mean, we're also talking about LGBTQ status, sex, you name it, all the way up to race. I mean, if this does not apply, if these rules do not apply to these churches, there's no reason that they can't discriminate on the basis of race. And we also know that other groups out there, like the Alliance Defending Freedom, which is sort of the anti-FFRF, they are already advising religious employers to give every employee, including receptionists, some religious duties so that they can take advantage of this exception from civil rights laws and fire any of them for any reason they want. This is really an alarming expansion of the. I mean, it really is just, it's mind blowing in a way.
It is, and Justice Sotomayor had sounded this alarm in her dissents. I've been really impressed with her dissents this term.
Yes.
She's really come out swinging. A lot of people give a lot of credit, which is definitely due to Ruth Bader Ginsburg, but really, Sotomayor has become a really good friend for us. She pointed out the contradiction in these cases from this term, and I want to discuss that next. It's a great segue to our next topic. What is the current state of religious liberty and our establishment clause? So she wrote in her dissent, recently, this court has lamented a perceived discrimination against religion. Yet here it swings the pendulum in an extreme opposite direction, permitting religious entities to discriminate widely and with impunity. So, Andrew, yesterday I listened to your interview with our friend Andrew Torres at Opening Argument podcast, and you talked a lot about this point. Can you share with our viewers, what does Espinoza together with Our Lady of Guadalupe mean?
Yeah, I mean, so remember, Guadalupe is about the ministerial exception, and that only exists because we have the separation of state and church, right? So they're using the separation of state and church to say these churches and Catholic schools and hospitals can fire any of their employees who have any religious duties for any reason, right? They're basically citing separation of state and church for that proposition at its most basic level. And yet in Espinoza, the court maligns and undermines and casts aside the separation of state and church as discrimination itself. So religion gets all of the benefits of state church separation and none of the burdens. And that is really the big problem that we've seen at the Supreme Court this term, in my opinion. So, I mean, religion is different, right? Under our constitutional order, it is a beast apart. And it used to be set up that religion and the state were these two wary animals circling on either side of a wall, keeping out of one another's territory. But now you've got one animal and a parasite on that animal. So before there was this hands off, you do your thing, I'll do mine. And religion would even claim state church separation to get some special privileges like, hey, the ministerial exception, don't get involved in our internal disputes over doctrine. But now churches have argued and won. And basically what they've said is, look, if you treat us differently in a way we don't like, that's discrimination. If you treat us differently in a way that benefits us, though, that's because the Constitution requires it, because the Constitution separates state and church. And that is religious privilege at its most basic level. Churches want to have their cake, which they think the American taxpayers have to buy, and eat it too. And this is just, I mean, it's rewriting 250 years of law and precedent. This is unbelievable what we've seen this term.
And I think what's shocking is they're not winning. They're winning some people who we thought were friends too. On the day the decisions came down last week, many were shocked to see the majority in both cases got votes from Justices Kagan and Breyer. So I want to ask you guys, are you shocked about that? And what does this mean for future religious liberty questions before the court? Have we lost Kagan and Breyer on? Patrick, I'll start with you.
Yeah, I think one thing to look at is not necessarily just counting the votes, because on some of these cases you could say it's 7-2, but you have to look at the rationale. So in the context of the opinion on the contraceptive case, Little Sister's case, the rationale was, okay, the government has the ability or authority to do this, but that doesn't mean that they're going to win the ultimate case. And so they kind of point out, I think, a roadmap for the states of Pennsylvania, New Jersey to challenge the provisions. But as a legal determination, I think they're being principled and saying we think the court or the executive office can decide how big or small the contraceptive exception is. That has implications for future presidencies too, because a president may well make that a very small contraceptive exception, applying to a smaller number of employers than it does today. So I don't think it's bad in that sense. In the larger sense, I think on some of these state church cases, it's been troubling. Certainly that Kagan in particular, who has formerly represented the government, maybe has been inclined to kind of give the government the benefit of the doubt, or kind of think that there's this reasonable compromise between religious adherents claiming exceptions or exemptions from laws, and I think that she's on the wrong side of a lot of those cases, because I don't think that they're really willing to compromise, as Andrew's pointed out. I think in terms of Little Sisters, that they want to kind of impose their religion on other people. It's not a matter of just an accommodation. So overall, it's been concerning Kagan, and Breyer has always been a little bit a middle of the road in terms of religion in government. He was a deciding vote in the Van Orden versus Perry case, allowing the Ten Commandments to be put up or to remain at the Texas Capitol in 2005. So he's always kind of favored a judicial weighing test without clearly being always state church isn't being an important factor. So that's my take on it. I don't know, Andrew, if you've got another take.
I mean, I think you're right to identify the Van Orden and the McCreary cases in 2005, the two Ten Commandments cases that were both 5-4, and Breyer was the deciding vote in both those cases. I think that is really indicative of Breyer's, I hesitate to call it jurisprudence when it comes to state church separation, but let's say his view when it comes to state church separation. His view is, I think, supremely political, right? It is, I'm going to make the most politically popular decision I can when it comes to these issues. And if you read his opinion in Espinoza, the Montana case from last week or 2 weeks ago, excuse me, he is basically saying, look, courts should just decide this on a case by case basis. And in this case, it's wrong. And in other cases, it's going to be right. And he just wants the ability to decide each case less on a legal principle than on, I think, the political wins at the time. And I don't mean political in the sense of political parties. I mean political in the sense of, is this going to upset the country? Popular opinion might be a better way to put it. Kagan, I don't think has been that much of a friend of state church separation since she's been on the court. I mean, you can go back and look at the Bladensburg Cross opinion, and look at the Trinity Lutheran opinion. And the thing that is the most alarming to me is that this is bleeding over into a desire or a willingness to bend all the procedural and normal rules to treat religion with these kid gloves, to privilege religion. So in the DACA case and the June medical case, and even the Bostock case, you get these good, correct decisions. But when it comes to religion, there's no political cover that's needed for the court to bend over backwards to rewrite the facts and even ignore the procedure to privilege religion. And you can go back and look, and we've talked about it on this show a lot, the Trinity Lutheran case from 2017. There was no adversity in that case. The parties agreed on what was happening, and still the Supreme Court decided it. That would never have happened if it had been one of the cases that FFRF brought. In Espinoza, standing is always an issue, but not there. There was no program that could even be challenged. It was gone. It literally could not have been a case about discrimination because there was no government program in place. And standing is always an issue in our case, but there the parents, quote, intended to apply for scholarships, and that was enough. The court didn't even look at standing. Guadalupe, the case that we were just talking about, discriminating against those teachers, that was a case on summary judgment. The facts should have been looked at in the light most favorable to the two women who were fired. And instead, the facts were rewritten, and then they expanded this ministerial exception beyond all recognition. Right? At the very least, the women deserved a trial on the facts. But, why allow the truth when you can privilege religion under law? So, I'm shocked by the amount of judicial activism that we have seen from this court. And taken as a whole, when it comes to state church separation, I really think it is unprecedented and deeply, deeply alarming.
I agree. I feel that I'm never going to forgive Kagan for her siding with the majority in the Bladensburg Cross case.
Unbelievable.
We already know that the court is considering more religious liberty cases in the 2020 October term. Which ones are they, and will FFRF be involved in some way, Patrick?
I'm having a little bit of a hard time hearing you, but I know that we were going to talk about our the 2020 Supreme Court term. And one of those cases that we submitted a brief on, this is going to be argued this August, I believe, or maybe it's going to start up this fall. Tanzan v. Tanvir is a case where FFRF submitted an amicus brief arguing that the Religious Freedom Restoration Act, which is the source of some of these problems, the contraceptive cases, is unconstitutional. And so there the court's going to be deciding a more narrow issue, which is really whether federal employees can be sued for damages under RFRA, which would have some implications on state church cases and people suing for religious liberty cases. And the big case that's coming up, which we're planning on submitting a brief also, is Fulton versus the City of Philadelphia. And that involves where a government contractor, foster care agency, is claiming a right to discriminate against prospective foster care families that are headed by same-sex couples. So the city's contract does not permit discrimination and requires the agencies to accept all families. They're challenging that on saying that it would violate, their religion. And so it's interesting that the Supreme Court took that up, because if we take their kind of state church, if we piece all the cases together from this term, I think we should see the Supreme Court in City of Philadelphia allowing the city to create its own rules, not allowing for discrimination. Of course, we don't know how the court will treat that, and it's concerning that the court actually took the case in the first place because the city had won at the Court of Appeals level. So these are, at least two upcoming cases in the term that we're watching. I know that there probably will be more as the Supreme Court grants cert in more cases.
Thank you. And I apologize for the audio. We are having some issues today because our studio got revamped over the last week. In fact, I have a crazy echo in my ear, so it's really messing with the way I'm talking right now. I'm sorry about that. But I do want to take our audience. We do coming in. So the first is from Melissa Thorpe via YouTube. Could I request a link where I can donate to support women needing abortions in Wisconsin? Yes, you absolutely can. You can donate to the Women's Medical Fund at wmfwisconsin.org. This is a nonprofit organization that FFRF houses, and we provide funding for women to get abortions. The website is right there on your screen right now. The second question is from Tempe Mont. He asks, are there any state church cases that the Supreme Court didn't take up this year that you wish they would have?
I don't want this court deciding state church cases. No, I mean, I want this court to not decide any state church cases until the court can be fixed. I can apply that to the whole federal judiciary for the most part. Pat, you want to be more curious?
Well, we were concerned. No, we were concerned that because in one of our cases, we have a challenge against Bible instruction in a West Virginia school system that on standing grounds petitioned the Supreme Court to hear a case last term. And the court rejected, although it asked for a response from us, it ultimately rejected the petition and the case wasn't taken. So I did not want them to take the case, but certainly we've been watching what cases they're taking. And I think I agree with Andrew. We generally don't want the court to take cases because I don't think they're going to, rule correctly on a lot of these. So we would hope to obviously avoid the Supreme Court if that's possible.
Yeah, I mean, it's a good point though, Pat. I mean, the other side right now, Christian nationalists, the anti-FFRFs, the people really pushing to tear down the wall of separation between state and church are desperate to get to this Supreme Court. So they're doing all these really strange, odd procedural things to get up to the court because they've seen what the court has been doing in cases like Trinity Lutheran, like Guadalupe, and deciding these cases when they really ought not to be. So in a lot of the FFRF cases that are ongoing before there's even a final result, you have the other side pushing to desperately try to get to the Supreme Court. We saw it in our New Jersey case. We saw it in our Orange County, California case where we were dealing with school board prayer. We won against that school board. The school board voted not to pursue the case to the Supreme Court. And a neighboring school district came in and tried to take the case to the Supreme Court, even though they weren't involved in it at all. Never seen anything like that in my legal career. And we talked to a lot of other attorneys and nobody's ever seen anything like that. They're just desperate to get to the Supreme Court because they know they are going to be favored, which is really, really shocking if you think about it.
Absolutely. And I think that this term has just highlighted how important our work is. As we're facing these challenges, we have more to do, and we're expanding our efforts not only in litigation, also in legislation, and not litigation advocacy, education. But it's really important work, and I think that our team is ready to take up this challenge and really hard for the rights of our members and religious people in America. There is one question today. It's an interesting one, and I'm interested in answering it because I feel that probably a lot of people think about this. Steve Sinkoffer asks, just out of curiosity, are there any open religious people working at FF? Now, honestly, I don't know the answer to that. I mean, I don't think that they're open if they are religious, but we have had people who have been religious working for FFRF in the past. In fact, one of our lawyers was a practicing Christian, and she really believed in the separation of state and church. So they can come and work at FFRF. I think that they feel welcome. I don't know if you guys have any thoughts on that, but
I mean, I think what FFRF is fighting for at its most basic level, the separation of state and church, protects the right of every American to worship as they see fit, right? There's no such thing as the freedom of religion without a government that is free from religion. If you want religious liberty, secular government is a prerequisite. And that is what FFRF is fighting for every single day. And that's why we do have staff and members, lots of members who are religious and of one stripe or another, because that mission is critical to some of their most cherished rights.
Well, and thank you for that to our show. That's Ask an Atheist for this week. Thank you for joining us. If you want more information about the Freedom of Religion Foundation, check out our website at ffref.org. We'll be back next Tuesday at noon Central with another episode of FFRF Ask an Atheist.